Hello everybody, my name is Anju, Balakrishnan. I'm legal intern of LEXIS and Company. And I want to first begin with saying welcome back to our channel. Thank you for visiting our channel. If it's your first time here, please press the like and subscribe button. Also click the notifications buttons in order to get more law related videos in the upcoming days. So today's topic is going to be about mediation under ADR. ADR is Alternative Dispute Resolution. So let's begin with the definition or the understanding of what ADR is. Alternate dispute resolution is basically the consequences considered to be or said to be a consequence of all the issues or result of all the issues that the public has faced in the courtroom on a regular basis. It was because of these issues that a concept of ADR was formed. It basically ADR functions as a replacement for the conventional way of settling disputes and administrating justice and is considered to be a contrast of litigation. In ADR, ADR focuses upon providing justice through the mutual consent of the parties in a shortest amount of time, in a shortest period. Basically, they try to solve the problems between the parties in a small time by bringing the parties together and talking to them and mediating or trying to get a decision, making a decision on the mutual understanding or the mutual base on a mutual consent of the parties. The ADR consists of 4 procedures, which are known as arbitration, conciliation, mediation, negotiation. Today we are going to talk about mediation. Mediation is a process where the disputing parties use the help of a third party. The third party would be a neutral party known as the mediator, and this neutral third party or the mediator would try to mediate their disagreements. It is basically a non-binding method in which the mutual third party or the mediator aids the disputants or aids the parties in achieving a mutually agreeable and agreed upon settlement. Two parties have brought together, they're sat together, the problems are heard, and the solutions will be put in front of them, and the parties would decide upon which solution is more convenient. They would mutually agree upon the solution. And this third party who listens to them and provides the solution would be a neutral person who has no particular bias towards anybody. He would be completely neutral, completely unbiased. So there are some principles of mediation. The principles of mediation is that the parties should go voluntarily. No one should be forced to go to mediate. It should be upon the parties to decide whether they want to go to mediate or they want to go for litigation. You cannot be forced to go for mediation. You cannot be forced to go to litigation. You can provide the parties the options, the benefits, the disadvantages of both, all the options of ADR, of mediation under ADR, as well as litigation, and the parties would choose upon which is the best one and take the decision upon their own. They would freely participate if they want to participate under mediation. The next one is that confidentiality matters in the process. The mediator under no circumstances must relieve any confidential information within the mediation unless they grant permission to do so. Otherwise, if there is a criminal purpose or an act involving self or harm or can cause harm to others, the mediators can reveal it. But unless and until there is no other problems that could be caused or there's any criminal purpose, the mediators have to be confidential and should not reveal the matters that they know. The mediators have to be impartial. As I mentioned before, the mediator would be an unbiased or neutral third party. They have to be impartial. They have to be objective while listening to the problems. They should adhere to all the guidelines provided in the mediation process and should evaluate the situations on a procedural manner. A mediator is not supposed to make any comments, value judgments, or provide advise or solutions. They are supposed to just listen to the situation and provide a solution on the basis of the situation. They're not supposed to give a personal experience or they're not supposed to provide any sorts of comments. The party should be able to recognize the impartiality of the mediators and should be able to understand their commitment in settling the disagreement. The mediation should be without prejudice to other procedures. So basically, the individuals must always have the options to alternative methods. They should be provided, as mentioned before, they should be provided with all the other methods. They should have the option to resort to all the other alternative methods. And if mediation is viewed as or it's found out this mediation process was a forced technique that would take one's individual right, then it would limit their creativity and raise sorts of resistance. Now, there are some benefits of mediation. I would cut it short. One is that the mediator does not force the judgment upon the party. Uh, Courts and legal precedents are used. However, they would not be able to force decision upon the party. They would assist in maintain a business-like attitude to conflict resolution. And if this solution is not accepted, then it's up to the parties. However, you can provide a solution. It would be up to the parties whether they would accept it or not. Cannot be forced upon them. The next one is privacy and confidentiality. The benefit, as I mentioned before, there would be full confidentiality, and the mediation would be in a private location or such as in a conference room, and it would not be made to the public, and the information would be kept privately. The next one is time and cost savings. It's considered to be a speedy process, and the average duration of a mediation is considered to be 1 day. And due to the high technical issues of many parties or complex problems that may take longer, if there are some sort of issues or some sort of problems, it may take more than 1 day, but basically the minimum time limit is 1 day, and hence it saves a lot of money because court proceedings takes cross examinations. Hence, the payment for the lawyer keeps on increasing, or it keeps on going. You have to continue keeping the payment for every sitting or every hearing. Mediation, as it's a short process, it saves a lot of money and avoids lots of formalities when compared to that of litigation. The next one is control. The party would have the ability to choose whether or not to participate in the mediation, and they would have the ability to decide if they want to withdraw from the process. They have the ability to maintain control over the negotiating process. They have the ability to control whether they like the solution or not. The parties would have a lot of control that is not available during the litigation process. So basically, mediation is a non-binding voluntary procedure in which a neutral and unbiased mediators assist conflicting parties in order to reach an agreement, and there are benefits such as informality, privacy and confidentiality, time and cost savings, and control. I hope that you can understand mediation under ADR. And if you understood the video, please press the like and subscribe buttons in order to get more related videos in the upcoming days. I hope that you have a wonderful day ahead. Thank you for your time and understanding.